How are we doing, credit repair? Pre-lit community, Stephen Palmieri coming to you here. And today we are going to bust a little myth that is out there. The myth is that the dispute must come directly from the consumer when communicating with the credit bureau. Myth is busted. This is in fact not what the FCRA says. This is not what the credit bureau's own correspondence to consumer says, and this is just not true. So as we're doing this, if you are joining us live, feel free to put in your comments below and we will make this an interactive session. So let's go ahead and jump on into it. So how many of us have been taught or have read or have been led to erroneously believe that the consumer must send, or it must appear as though the sending of the dispute comes directly from the consumer? Well, that is not true. Let's take a look and show you guys where. Let's see here. Let's go ahead and do a little share screen real quick here. All right, let me pull this over. We're going to do a little share screen, and we're going to take a look and see exactly what the FCRA does say, so you can now learn what it does not say. All right, so 1681I, this is where your procedure is for disputed accuracy. This is basically where your ability to send a dispute to the consumer reporting agency comes in. And what it says up here is, basically, if the completeness or accuracy of an item of information contained in a consumer's file is disputed by the consumer, okay, so it does say consumer, but it doesn't restrict it only to consumer, okay? I mean, it does not say the consumer cannot have a legally authorized representative. The FCRA did not restrict consumers. That's important to know. But that's not even where people get confused. And if the consumer notifies the agency directly, it is this word directly that is so misunderstood by everybody. So let's talk about that. So what this is actually saying is if the completeness or accuracy of an item of information is disputed by the consumer, or it can be the consumer's legally authorized representative, there's two ways in which the consumer can dispute the information. That's what we are saying right here. Number one is they can notify the consumer reporting agency directly. Remember, the consumer reporting agency, Equifax, Experian, TransUnion, whomever it is, those are the main companies, the repositories that house the data. So it is saying this word directly actually modifies agency and not consumer. You can either send a notice directly to the consumer reporting agency, or you can send a dispute indirectly to a reseller. So it's actually saying there's two different ways in which the consumer or the consumer's legally authorized representative can send a dispute. You can dispute directly to the credit bureaus, consumer reporting agencies themselves, or indirectly through a reseller. So what is a reseller? So your resellers are basically those intermediary companies that pull reports and then compile them. Usually they put them into tri-merge type format. They produce them for car dealerships. They produce them for mortgage companies. All those third-party type reports are typically resellers. In other words, when you go and you go to your mortgage guy or gal, they are not pulling the credit directly from the credit bureaus. They are pulling it indirectly through intermediary companies called reseller. All right, let's take a look where reseller is. I've got another little section here. So 1681A is where all of your definitions are in the FCRA. Okay, and it does tell you what a reseller is here. 1681AU says the term reseller means a consumer reporting agency that assembles and merges information contained in the database of another consumer reporting agency or multiple consumer reporting agencies concerning any consumer for the purpose of furnishing such information to third party to the extent of such activities. And so it has to meet both of these parts. So number one is they have to pull information from other consumer reporting agencies, and They do not maintain the database of the assembled merge information. Okay, so this is what a reseller is. It is defined here in 1681A, which is at the very beginning of the FCRA. Okay, so what this is saying, let's go back to 1681I, is very clearly saying that they can notify the consumer reporting agency directly or a reseller. Why they say indirectly? Well, because it will end up indirectly to the consumer reporting agency, because the reseller is supposed to conduct their own investigation, and if they can't figure out that it's a problem that they created, they will then forward that dispute to the consumer reporting agency, which means it will indirectly make its way from the reseller to the consumer reporting agency. Okay, so it's absolutely busted myth that you cannot use a power of attorney or have a legally authorized representative, which is if you have even a credit repair organization. This is what I do. You get a notarized power of attorney from your client, you send it in with the letters on your letterhead, and you do not need to pretend to be anything else. Now, let's go ahead and shift gears real quick here to the other part of the FCRA that has to do with furnisher direct disputes. Okay, 1681S-2A. 8, if we go down here, is kind of where the ability for consumers to dispute directly with furnishers. Okay, the consumer can send a dispute directly to the furnisher. Now, it is true that in this section of the FCRA, it does state that furnishers can, in fact, disregard disputes that originate or appear to have originated or been prepared by a consumer reporting agency. Okay, this is kind of like their little get out of jail free carve out. Well, because why would they have put this into the law? Well, number one, because our industry is not really very well organized, and we don't really have lobbyists to make sure that our interests are preserved when laws are passed. But apart from that, the other companies have lots of lobbyists, and they're like, dear Congress, we get all of these nasty letters that we just know are not coming from consumers. We can barely even read them. They're like little gnats flying all around us. What can we do? So they got Congress to write in here that, if they get these letters, if in fact it came from a credit repair organization, which is a big if, because they're going to have to make an assumption, right, if they disregard the dispute. So they kind of open themselves up to a big liability there. But the point is yes, the FCRA does in fact state that they can ignore a dispute if in fact it was prepared by a consumer reporting agency. Now, that being said, if you are operating not a consumer reporting agency, a credit repair organization, if you're operating your credit repair organization as a legally authorized representative with an actual notarized power of attorney from your client, it is almost not heard of for a furnisher to not accept a furnisher direct dispute when it comes from you on your letterhead. I do this all the time, been doing this for over 10 years. Worst case scenario, in that less than 1% chance they do deny it, have your client notarize the letter, turn it into an affidavit, resend it to the furnisher, and now they're going to have to accept it because it's an actual affidavit that's been adopted by your consumer. But the way around this is simply get a power of attorney, because but once you are a power of attorney representing the consumer, you are in a much different position than just a regular credit repair organization. You're now a fiduciary representing the consumer. And, these furnishers just have a button in their system that says, is there a POA on file, yes or no? I mean, let's think about it. Let's think about how debt settlement companies operate. They get powers of attorney from their clients, from the debtors, and they send them to furnishers. So having a power of attorney button on the furnisher's computer or the creditor's computer, it's just normal course of business. Okay, so really, this is really intended to basically to teach us a lesson how to run businesses, if you can ask my opinion on it. They don't want to get these deceptive letters, and I really can't blame the furnishers, to be honest with them. But if you were to send them letters on your letterhead with a notarized power of attorney, almost every single time they will be accepted. All right, so that there is where in the FCRA you guys can find the misunderstood portion of the FCRA that has to do with disputing with the consumer reporting agencies. We've looked and shown you what reseller actually means. And of course, we've gone and shown you a nice little trick how you can use a power of attorney to communicate directly with the furnishers. The nice thing about that power of attorney with the furnishers, it opens up a whole lot of other ways to communicate with them. In addition to just having letter writing campaigns, you can email the furnishers if you need to. Once they've accepted your POA, you can phone call them, and those are beauties, especially if you can call debt collectors and record those calls. Man, my goodness, you're getting all sorts of good stuff that you can use against them, and then to eventually escalate up to the CFPB. So there you guys have it. It is in fact a busted myth that you cannot communicate directly with, or that you cannot, as a consumer, have a third party legally authorized agent communicate directly with the bureaus. Absolutely not true. You just have to do it the right way. You just have to get a notarized POA and put the recipient on notice that you're actually acting as a POA, as if you were in any other industry or business in the world where that's kind of how it is done. So hopefully this helps you guys. Go ahead and, again, comment below if you have questions. Let's see, we do have one question popping in here. Let's see, Robert Sigmund, my good friend from Kredzu. If Congress wanted something excluded, they would have excluded it. Yes, Robert, that's exactly right. That's exactly the point. Is it uses the word consumer, but it does not say only consumer, or it does not further elaborate that consumer is restricted to like only mean consumer. So you're exactly right there. So awesome. Well, don't see any other questions popping in. If you want to learn more as a credit repair organization or an FCRA attorney, how we can help bridge the gap, get these two worlds talking to each other, go to creditrepairtrainingcourse.com and go ahead and look at my information there. Let's see, Warren says live on a Sunday night. What a dedicated teacher. Warren, I actually am doing this for you and you only. Everybody else who's watching it, you guys got to benefit. This was Warren's show. That being said, you guys be good, and I will see you all on the next live. Take care.